A couple thoughts here. First, what if it goes against Trump? What can Trump do? You think Trump hasn't thought about this? You think his team doesn't have a fallback position? Like they might turn to license requirements? The anti-tariff people tried to attack that, and that's not a question before this court. So normally, you would not expect a court to, in its decision, to address a legal question that wasn't put before it in any of the arguments. I'm not sure I've seen it ever mentioned in any of the motions filed with the court, any of the briefs filed with the court, I should say. So if they take out tariffs, but they don't mention licenses, can Trump just start charging for licenses, right? Every item requires a 50% license. Could Trump do that? Or is the Supreme Court going to try to preempt them? I think either Gorsuch or Kavanaugh, I couldn't tell who it was, brought that up. It's like, is Trump just going to find another way to accomplish the same goal? Because the president does have many other delegated tariff authorities, many. Is he just going to find another way to achieve the same goal? In which case, are we just going to be back here in 6 months or be back here in a year? Would that not just make this pointless? And I think Trump has other ways. I think his team is ready, if this goes against him, to say, all right, we're not going to use IEEPA. Supreme Court said we can't do that. So we're going to embargo everything and issue licenses for embargo for a fee, or they'll do layers of tariffs. This statute says we can only do a 15% tariff. All right, we're doing that one. And here's another statute that says we can do another 15%. All right, we're going to layer that on. So now it's 30%. It just makes it more cumbersome for everybody. But there are a lot of delegations of tariff authority to the president. It just makes it, but what would you do? I would just punch it all into Grok. If I were the Trump team, I would call Elon and say, hey, can you give us like a dedicated Grok server? And it'll calculate out the most efficient way to apply collectively every tariff statute we have that's incontestable delegation to the president and achieve the closest we can get to this much simpler outcome. That's what I would do. That would work fine if you had, if there were no shenanigans, everybody was being above board, and you had two nations that were effectively economic equivalents. So similar size economies, so that there were similar opportunities for each country to sell into the other country, similar opportunities, similar benefits, right? That then reciprocal tariffs in a very clean way seem to me to be feasible, possible, makes sense. But that's not the real world if you're America. There is no comparable economy to America. There just isn't. We are unique American culture and society and traditions and heritage and policies and laws have built an economy that is greater than anything else that exists on the face of the earth. I think America should just say, we don't even know. You say reciprocal tariffs, wah, wah, wah. We don't even hear those words. That's not what's on the table here. What's on the table here is we built this American economy. And if you want access to this economy, you want to make money selling to this economy, you have to pay a participation fee. And we're going to structure the fee based on how much you're making, how much you're sending us. And that's going to be a tariff. And we don't care if it's reciprocal or not. In fact, we feel that we have every right to charge you a 30% tariff and tell you can't tariff us at all. That if you tariff us 1%, we're going to increase our 30% tariff to 60%. And if you tariff us 5%, we're going to increase 60% to 90%. And if you tariff us 10%, we're just going to go all the way to 100%. We're not peers. We are not economic peers. We're not obliged to limit the fee we're charging you to access our unique world dominant economy based on what you're letting us do in your minuscule economy. These are not the same things. So I think America should be imposing tariffs on the world simply completely independent of what they're doing. Not reciprocal at all. Completely as a cost of access to the American economy. By the way, that's how America used to pay its bills. That's how the federal government used to largely pay its bills, was through tariffs and similar means. Why can't we do that again? If we've brought in something like $8 billion in tariffs so far, if countries are not going to adopt the policies we're urging them to adopt, which would be our preference, Why not just pay our bills that way? Wouldn't that be nice? Wouldn't it be nice, in his first term, Trump would say, well, how are you going to pay for this wall with Mexico? He says, I'll make Mexico pay for the wall. Why don't we make the world pay for our healthcare? Wouldn't that be great? So that's my position on it. I mean, that's one of the many ways I'm America first. I have no problem making the rest of the world pay for our national healthcare. And if they don't want to do that, they can just not access our economy. They can build their own economies. More power to them. India can become an economic powerhouse instead of an open air toilet. More power to them. I wish him the greatest of success.
Rebuttal, General Sauer.
Thank you, Mr. Chief Justice. Just 3 points. One, an interpretive point. The statutory language here is regulate importation, and again, by means of instruments, licenses, or otherwise. Their argument is that that phrase carries with it a whole host of unenumerated forms of regulation, including quotas, licenses apparently that come with fees as long as they're sort of profit neutral fees, environmental restrictions, qualitative restrictions, reports, and so forth. It's just that the one form of regulation that they would not include is tariff regulation, which of course is the quintessential, most historically tested method of regulating imports. And so that additional phrase about, by means of instruments, licenses, or otherwise, really sort of reinforces the plain meaning, the ordinary, natural meaning of regulated importation here. So when it comes to just the plain text of the statute, their argument is a donut-type argument, and it's not an argument that does justice to the statute's plain text. On the non-delegation point, Justice Gorsuch, you alluded to the founding era delegations of the Indian commerce power, and I just remind the court that in 1790, in July of 1790, Congress passed a statute that essentially delegated to President Washington essentially the entire scope of the Indian commerce power. He said you can do commerce with Indians if you have a license that you had to pay a fee for, and that will be subject to such rules and regulations as the president makes with no further guidance. So when it comes to this foreign-facing, it's obviously analogous because it's the Indian tribes, not foreign sovereigns, but this foreign-facing situation, we have a very sort of deep and profound historical pedigree through broad delegations of the regulation of commerce, right? The foreign commerce power, in that case, the Indian commerce power. And that ties, I think, to what I take to be the main theme of the arguments on the other side. And I think that Mr. Catchall started by saying tariffs are taxes. And I want to complete the answer I think I was giving to the Chief Justice when I got interrupted is if you look at these tariffs, these policies, it is clear that these policies are most effective if nobody ever pays the tariff. If it never raises a dime of revenue, these are the most effective use of this particular policy. And I said there's 2 buckets there. One is, first of all, when it comes to the trade deficit emergency, if no one ever pays the tariff, but instead they direct their consumption domestically and spur the creation of the rebuilding of our hollowed out manufacturing base, that directly addresses the crisis. It's more effective if no one ever pays the tariff. That's the point of it, really. That's a fundamental point of it. And that's one piece of these. And then as to both of them, as to both of the declared emergencies, the tariffs are an incentive, a pressure point, leverage, bargaining chip, as the court said in Dames and Moore, to get countries to change their behavior to address the foreign arising emergencies. So if you look, for example, to take a historical example, last week's trade deal with China, it unlocked access to rare earth minerals, which of course have a critical national security aspect to them, and it got China for the very first time to change its policy with respect to fentanyl precursors, which is a crucial piece of that. Those tariffs, if no one ever collects them, but the threat of imposing those tariffs gets China and our other trading partners across the world to change their behaviors in a way that addresses this, then that's the most effective use of the policy. So they're clearly regulatory tariffs, not taxes. They are not, they're not an exercise of the power to tax. They are the exercise of the power to regulate foreign commerce. And that's why the statute says regulate. It doesn't say tax, it says regulate. And for that reason, we are squarely within the tradition that I was talking about before of very broad, historically very broad delegations of the power to regulate foreign commerce to the president because he has inherent Article 2 authority in the area of
very strong rebuttal
foreign affairs, although not that. It has to be delegated to him, otherwise the delegation would be superfluous. And for all those reasons, we ask the court to reverse both the decisions below.
Thank you, counsel. The case is submitted.
All right. That is the oral argument. That was a super rebuttal. All right. So stuff to talk about. So really the biggest constitutional argument that was raised by the Neil Katyal arguing against the tariffs. And as I said during the oral argument, whatever you may think about Neil Katyal's politics or the position he's taking on a case, he's been around forever. he's like a god level attorney, and he's really that good. I mean, if he were someday on the Supreme Court, it wouldn't surprise me. He's a world-class attorney. John Sauer, also a world-class attorney. So we had really good attorneys here. So I just want to make that clear. However, I criticize Neil Katyal's arguments here, and I have criticisms for everybody, of course. I want you to be aware that this is a world-class attorney we heard argue here against Trump's tariffs. All right, so the strongest argument, in a sense, kind of constitutionally founding of the nation argument that the anti-tariff people are raising is that tariffs, they start with the presumption, which I reject, that the tariffs are taxes. They're revenue raising. After all, Trump has already raised $800 billion. He says he's going to raise $4 trillion, whatever the case may be. These are revenue raising, and anything that's revenue raising is so intrinsically within the power of Congress that there's no way they delegated that authority to the president in the absence of absolute clarity, the most explicit possible language. And the IEEPA, the relevant statute here, doesn't actually include the word tariffs, doesn't say you can charge taxes, doesn't say you can raise revenue, says you can regulate imports. And of course, the Trump people are saying, well, obviously the most fundamental way to regulate imports is with tariffs. It's the most common way, the most natural way. But the opponents are saying, well, if you're raising revenue, that's taxes. Taxes are so inherently, the founders placed the taxing power in Congress because it was that important. After all, we were dealing with the tax stamp. We were dealing with all kinds of taxes from Britain leading up to the Revolutionary War. And we were shouting, no taxation without representation. Parliament, the parliament of the nation of which we were citizens, England, were the ones imposing the taxes, but we didn't get to vote for parliament because we were a colony. So we were shouting no taxation without representation. It's one of the reasons we revolted against British rule. And by allowing Trump to charge these tariffs and raise revenue, and the notion is not just that the tariffs are revenue raising and therefore taxes, they're taxes on the American people is another presumption that I reject. But if you believe that they're taxes on the American people, that must come from Congress. And there's related doctrines, the non-delegation doctrine and the major questions doctrine. The non-delegation doctrine says that if Congress is going to comprehensively delegate away a power without limits, that's not allowed. Congress cannot simply give away its Article 1 authority. It doesn't actually belong to Congress. It belongs to the U.S. Constitution. And Congress can't simply give away the power to vote on a bill, for example. It cannot give away the power to vote on an impeachment in the Senate. Can't just give that to the president. We're not going to vote. The president just gets to vote on impeachment. Can't do that. That's a core power of Congress. Can't give it away without limitation. Now, of course, Congress can delegate powers, but when it delegates powers, it has to do so in a controlled way. There's limits, there's time limits, or there's subject matter boundaries, or there's other constraints around the exercise of that power, that delegated power. So it's not just a complete delegation of the power. That's the non-delegation doctrine. A related doctrine, and of course, what they're trying to say here is, well, Congress can't delegate away its taxing authority. So if you believe the tariffs are a tax on the American people, Congress can't delegate that core function without limit to the president. Now, even there, of course, the IEEPA does have limits. There has to be an emergency. Congress has checks on the emergency. The president has to report about the emergency. Congress can end the emergency. There are checks there, but those checks are in the Emergency Powers Act, a different statute. You don't find them inherently in the IEEPA. The IEEPA refers to the Emergency Powers Act. Activation, invocation of the Emergency Powers Act is required to then activate the IEEPA, but it's not explicit within the IEEPA itself, that those limits about the duration of the emergency, for example. Congress very much did not want a president to have an endless state of emergency. They wanted a check on that power, and they imposed it. The other major doctrine is the major questions doctrine. And the major questions doctrine says if a president is going to look at a statute and say, you know what, that I interpret that statute to give me enormous powers to make enormous changes, major questions of policy will be changed. That statute has to be extremely explicit that it intends to allow for these changes, these major changes in a public policy. It can't be kind of a subtle reading between the lines, a weird interpretation of a statute. It has to be extremely specific if there's going to be major changes. So here the tariff opponents are saying, well, look, Trump just tariffed the whole world on everything. That's a major change, and therefore it violates the major questions doctrine. The IEEPA would have to say, and the statute would have had to have said, in fact, we allow a president to tariff the whole world on all the things. And it doesn't say that. So they say that the statute violates the major questions doctrine. Of course, the Trump supporters say, well, it doesn't really violate the major questions doctrine because tariffs are not a major question. Tariffs are the most normal way in the world to regulate imports. And the statute does say the president can regulate imports. So it's not a major question. And his response is proportional to the declared emergency, which is a global emergency. Right? Our COVID emergency was a global emergency, right? Responding to a global threat. So that's certainly permissible. So those are a couple of the doctrines at play that they were raising. I find all of those to be rather uncompelling. Again, the tariff as a revenue provision, a tax on Americans, I think that's ridiculous. It happens to have raised a bunch of revenue, but the purpose of this tariff is not. No one said, hey, you know what? We need to raise a little more money. Let's put a 5% tariff on cork from Portugal as a revenue. We want the cork to come in. We just want to have basically a tax on the cork imports as a revenue raising measure. That's not what these are for. They incidentally raise revenue, but these Trump tariffs are intended to change behavior. Ideally, nobody would ever pay a penny of these tariffs. Canada would make greater efforts to stop the fentanyl coming over the border. China would make greater efforts to prevent the fentanyl precursors from making their way to China in the first place. All these different countries. The tariff we just put on India about selling its oil from the oil, rather buying oil from Russia, which Russia is using that money to finance the Ukraine-Russia war, which Trump wants ended. We don't want to get money from India over that. We want the revenue to Russia to stop, and by extension, the Russia war engagement to stop. But the purpose of none of these is revenue. That's just a happy side effect. What we're trying to get is behavior change. I don't think the non-delegation power, the claimed violation of the non-delegation authority works because there are a lot of constraints on this delegated power. The most important of which is it requires the emergency declaration, and Congress has oversight and control over the emergency declaration. They can end it. It's limited in number of days. Trump has to give them regular reports about the state of the emergency to help guide Congress's decision-making. It's not in any way an unlimited power of the president, and the statute itself is not unlimited. It constrains the things the president can do. One of the things he can do, regulate imports, would be tariffs, but it's not anything he wants to do. It lists the things he's allowed to do. One of the things listed, of course, is regulate imports. And I already talked about the major questions violation. I guess I kind of talked about it already, right? This notion, the premise, a fundamental required component to buy this should not be allowed, these tariffs should not be allowed because they're taxes argument. A requirement is that the taxes are being paid by Americans, but that's not at all clear that that's the case. I mean, it may seem common sense that a foreign supplier, their goods get to a U.S. border, they have to pay a 20% tariff or whatever, 20% tariff. They just add that tariff onto the price of their goods. But often that's not what actually occurs. Often if they added a 20% tariff to their goods, it would no longer be price competitive with the American domestic product version of that product. So often the foreign producer will simply eat the tariff. They'll just take it out of their profit margin. They've been making so much money selling it to America. They've been making a 30% margin. they can actually afford to take the 20% tariff hit and still be making a 10% margin and have access to the American economy. And then they don't pass the tariff onto the American consumer as a price increase. And in fact, when we look at inflation, there has been no price increase from the tariffs. So the notion that this is automatically a tax on Americans and therefore it triggers concern about Congress's taxing authority, I just don't think that there's any evidence to support that that's actually occurring. It's completely speculative. It makes sense that could be occurring, but where's the evidence? And courts are supposed to be applying the law to evidence. This whole notion, too, that everyone agrees Trump would be allowed to completely embargo goods from the whole world. Trump could say, hey, here's the emergency. And under the IEEPA, it explicitly uses the word embargo. I'm going to embargo all foreign imports. No foreign nation can send us anything. Everyone agrees that's within Trump's authority to do. And then to make the argument that, well, he's allowed to completely ban everything, but he's not allowed to put even a 1% tariff on anything, just doesn't make common sense, right? Doesn't make common sense. And once he's allowed to put a 1% tariff on, well, then what level the tariff should be is just a judgment call for the president to make. A lot of disingenuous grammar language from the liberals. Well, license, it says that Trump can require a license, but license is being used as a noun, not a verb. So Trump can require a license, but he can't charge for it. It's not an action item. If he's going to require a license, he simply has to issue the license. Really? Does that make any sense? Any of you have a driver's license? Did you have to pay for it? Was there a cost involved? And then they try to say, well, as long as it's revenue neutral, but that's not really true, is it? I mean, you think the government really knows when it charges a fee for a license, it knows for sure it's revenue neutral? What happens if the cost of issuing the license changes over time? Do they change the price of the license over time? So it correlates with changing? No, of course they don't. They just kind of arbitrarily set a license cost and they address it. Look at that. I was going to bring up suppressors, but of course that's a tax. That's a tax. Let's see. Lots of interruptions. Sotomayor loves to answer a question, let John Sauer get 3 words out and then interrupt him. Ask another question, 3 words out, interrupt him. That is completely her. There was also argument here. There's a whole section of the U.S. Code, Title 19, on tariffs. It's completely separate from this emergency provision. And she's saying, why would anyone go to that section if they could simply get past it using the IEEPA? And the reason is, you would go to that section when there is not an emergency, or what you're doing, you would not want to be checked by the limits set by Congress on how long an emergency can last. That's why there are different statutes and different sections for different purposes. Let's see. There's a whole question of not being reviewable or just justiciable, but I'm going to circle back to that in a moment. Let's see. And now, while I'm reading, is a good point for you to be typing in super chats, folks. Also, a weird argument by the anti-tariff people was that when there's an emergency, the president's authority should be more limited than in non-emergency cases. Of course, the argument for Trump, John Sauer, is when Congress drafts an emergency statute, right? In an emergency, the president has these powers. Well, no one can predict exactly what the emergency is, or the statute would say that, right? The statute would say, in the case of an emergency involving foreign troops or too many imports or whatever, it would be specific about the nature of the emergency. But Congress is often worried about, hey, what if something goes wrong that we haven't predicted? What if there's an unpredictable emergency? We want the president, we don't want to have a whole session of Congress to address an emergency that could be over in a week. We want the president to be able to act decisively. So we're going to create an emergency delegation of powers. When there's an emergency, the president can act right away. And because we don't know the nature of the emergency, we can't be too specific about how he can respond. His response is going to have to be fine-tuned to the nature of the emergency. So it has to be a general delegation of power. Here, the anti-Trump people were saying, no, when it's an emergency, it has to be even more specific. And that just doesn't make any sense to me. Everything in the law is contrary to that. So, for example, there's a doctrine in the law a legal defense to a charge for having committed a crime called the necessity doctrine. The general idea of the necessity doctrine is if you do something that's illegal, it's criminal conduct, but it's a relatively small offense relative to a harm that you're avoiding by committing the small offense. The necessity doctrine says you are justified in committing the small criminal act to avoid a much greater harm. And the classic example here would be you see a dog or a baby locked in a car on a really hot day. The windows are all closed, the doors are locked, and you know there's a real risk of death or serious bodily injury to that baby or to that dog. You look around for the owner, no one's around, you can't get the doors open, so you break the car window to save the life of the baby or save the life of the dog. The necessity doctrine would say, yes, of course, normally breaking the window in someone else's car, that's criminal conduct, that's criminal mischief, that's a crime. But we will forgive the crime because you committed a small offense to prevent a much greater harm. And every state has some version of the necessity doctrine. Some call it the doctrine of lesser harms or the doctrine of lesser evils, but they all have some version of it. But guess what all those statutes have in common? They don't specify what the harm to be avoided is, and they don't specify what you're allowed to do. They're extremely general. It's just after the fact. Somebody is going to make an assessment. All right, you committed a crime to avoid a harm. Now we're going to weigh those out and make sure it fits within the scope of the statute. But the statute itself is very general. And I think that's what that is obviously an example of an emergency statute. And I think that same principle of generality applies to any emergency statute. Or Congress could create an emergency statute that's super specific, but they would have to do that.